boldinvip.com.
Hey everybody, welcome to the Bold Inventors Show. I'm your host, JD Houvener, here with Bold Patents. I'm a patent attorney, and I'm accompanied with my trusty buddy, Matt Kulseth. Matt, how you doing today?
Hey JD, I'm doing great. How are you doing today?
I'm doing well. I'm glad to be back. We took a little break. It was like 3, maybe 4 weeks off. So it's good to be back. I appreciate you asking. We had some family stuff come up, and life happens. And my father-in-law passed away, and I had to kind of definitely kind of the blue, it's one of those things you have to just put family first. So we took care of some stuff there.
I'm so sorry.
Yeah, thanks, man. Appreciate that.
Yeah, life has a way of getting lifey, doesn't it?
Yeah, it does. It does. Yeah. So, but it's incredible how it keeps going.
Yeah, and it's relentless.
There are things that end and things that can start anew, and fresh starts, fresh perspectives. So I'm optimistic. I know you are too. So we're it's our job to do that. Obviously, cheerleading our clients or inventors that are inspiring and doing truly world-changing things. So, but yeah, it was good to take some time away from work. So, today we've got a good show today, but how are things with you before we jump into that? Anything going on in your world?
No, we're just getting ready to go on spring break. We're going out to Colorado. We're supposed to go skiing, but there's not much snow out there right now.
Okay.
So I think we're going to do some biking.
Okay.
Yeah, I think they're looking at up in Keystone area in Colorado. It's 55 degrees.
Oh yeah,
it's warm, like above freezing even at night.
Yeah, that's super warm. Yeah, it is very warm here. In central Washington, we're in the 60s. Kind of jumped up 10 to 20 degrees recently. So yeah, definitely spring has sprung here.
Cool. Yeah, we got our March snowstorm.
Yeah,
so
you did.
We got like 10 inches of snow the other day.
Oh, that's a big dump. Nice. That's good. Hopefully, welcome dumping there. Get to enjoy. You guys are pretty used to it up there in Minnesota.
Oh yeah,
good.
Great.
So we're going to talk about cost today as our major topic. I've got some stuff I've prepared. I think it's one of these things I revisit, and it's important. People will get confused. They get overwhelmed, and they don't know what to expect. Patents and trademarks. So we'll cover both those topics today. I do want to throw in our quick disclaimer, as we got a couple live viewers. We did trim down our live audience. We had some issues. We had some issues when we were going live on other platforms. On the YouTube, we've got over 10,000 subscribers now, Matt, for YouTube. So it's our home. It's where we're going to hang out. But by joining this broadcast here, do not share anything confidential, please. There's no attorney-client privilege to be said. But if you're interested in engagement, I'll provide a link later to head down that path to do a free discovery call. But if you do have any questions, and they're more hypothetical, more process-based, anything related to the law and intellectual property, plug them in. We'll put you to the top of the list. I've got a whole bunch of questions, and I've got just a few we can kind of work through to get warmed up, Matt. And then we'll jump to our topic, if that sounds good to you.
Excellent. Let's do it.
Okay. Perfect. So this one is, I thought it was quite good. I'm curious to see how you might answer it. And this comes from our audience on Quora on trademarks. So here, I'll plug the question in. Oh, I put the whole thing in. We just need to do part of it. Okay. And International Trademark Association. I'm not sure if you're familiar with that. How are they doing in combating counterfeit goods, Matt? Is there some magic?
Yeah, so this ITA, I believe, is one of these third-party companies that will register or renew your trademarks.
Okay.
I don't want to put my foot in my mouth or get us in trouble here, but I'm pretty sure that these folks are not legitimate.
Okay.
There's no such thing as an international trademark. The Intellectual Trademark Associate, or the World Intellectual Property Association organization, rather, is kind of in charge of international trademark patent matters. But International Trademark Association, I think this is a scam.
Okay, red flag. Take that letter if you got one. If you're worried about it, go talk to the registered trademark attorney and show them the letter. Have them again give you an answer. It might be worth a few $100.
There's a number of these folks that do this. They're constantly changing their names.
Yeah.
And they're not talking about
INTA,
INTA,
which I believe that's what I first thought when I read it. Maybe
they are talking about INTA.
Okay. Which is legitimate, at least so far as I know.
Yeah, which is a super legitimate organization. But INTA is like basically an association of like attorneys from all around the world. So like every year, like we can or do go to like INTA, which is a summit basically.
A big conference.
Big conference.
All of us attorneys get in there, get our CLEs, and learn all about the latest and greatest. But do they act as an enforcement body or
I don't think so.
policy-making body?
I don't think so. It's not. I don't think they have anything to do with it.
Okay. When I think of counterfeit goods, I think of like customs. I think of ITC, International Trade Commission, where perhaps you can move forward with federal proceedings to thwart counterfeit goods at the border, and if they've been, shown up in commerce here in the U.S. I'm not as familiar with those mechanisms, those civil matters. But I suppose INTA is not well known for combating counterfeit goods.
No, I don't think so. I mean, it's been a number of years since I've been to the conference, but as far as I'm aware, that they don't do any
Okay, fair enough. That was a little bit of an oddball one, curveball.
Well, I'm glad I actually looked up, I actually Googled it because, calling INTA, a racket would
no, right? Idea. No, thank you for doing it on the spot. And these are not pre-screened by you. That was a.
There are some other companies out there, like one of the acronyms is TMA, I think. There's some other ones pretending to be these organizations that send out, renewals essentially.
Okay, we got a live question right here. Nicholas Mortarillo, thanks for coming in. Can you file an application for a mark for a different class for a name whose trademark is dead or canceled for several years?
Ooh, good question. So can you file an application for a mark? Yes. For a different class for a name whose trademark is dead or canceled for several years. So it sounds like there's a brand registered. Obviously, Nicholas isn't going to tell us right now because that would be, don't do that. But basically, there's another name that he likes that's registered or was registered. Now it's dead or abandoned or no longer live at the USPTO. And he wants to file for a similar brand in a different category. Potentially, I still think you would need to talk to an attorney, me or someone else, to do a quick search for you and give you some better feedback on that.
Sounds good.
Yeah,
that's fair.
Just because someone registered at one time doesn't mean that you're going to be able to register again, even if their trademark is dead. Something could have happened in the interim time period. There could be a whole lot of reasons.
Okay, good. And is it true that even if it was for one class, it may have other classes or be confusingly similar in other classes?
Right. There are a lot of these classes are associated for likelihood of confusion purposes, analysis purposes.
Perfect. So, thanks for that question, Nicholas. Let's do one on the patent side, then we'll get to our cost topic for the day. This one is about trying to get a loan, to getting an IP-backed loan. I thought this was an interesting question. I don't mean through something like Blue Iron or another big organization looking for large, already existing success in exchange for millions. I would like something in the 5 to 6 figure range for 2 patents that I expect to own. And there doesn't seem to be a lot of reliable information about how to make that happen. To clarify, I want to use patents as collateral for a loan. Does one have any advice? Yes. I think I've got some thoughts here. And I think it's just to answer it plainly, let's assume that those 2 patents of yours do proceed to issue and grant, and you've got the rights, okay?
Yep.
And let's also assume you work with an attorney, and the breadth and claims are pretty broad. The question is going to be, what's the value of your patent? And a patent, when granted, it's an intellectual asset. That is a defined asset. It does have limited terms, but I mean, decades long, up to 20 years. It does perhaps have value, something that an individual or even an institution would be willing to, loan money against. You can get a lien against a patent asset. There are UCC ways to approach that. I think more commonly, patents are part of a package, a business plan, if you will. I've seen this happen a lot with inventors, business owners that apply for loans. Standard, old-fashioned SBA-backed loans through accredited lenders and banking institutions. While it sounds boring, that is really where the rubber meets the road. You can begin and open up a nice business, traditionally using SBA kind of backed lending criteria, and you bet their eyebrows will get raised, and they'll like the fact that you've got some novelty, right? And patent granted defines exactly that. And it will help, I think, increase your chances of getting that loan approved, maybe even the amount that you're able to get approved for, depending on other collateral you're willing to put up. I don't know if you're going to be able to get a loan purely on the patents. And that would be tenuous. If you don't have any commercialization, that is one important point. I'm kind of also assuming you just have the patents. But if you have got a product and you've got something that sells, or you've got evidence of infringement, clear infringement, those are all ways you can promote the value and increase the chances of getting a loan. Anything you'd add on that, Matt?
No, you nailed it, JD. It's so hard to evaluate the worth of a patent or a trademark in a market that doesn't exist, right?
Yes. Pre-revenue, it's challenging. I mean, obviously, with trademarks, even more so, it really kind of requires that. It is the brand. It's what customers, and to have customers, you generally
it's the goodwill, right? It's the goodwill associated with the brand, and a lot of times with our clients, our patent clients in particular, they're bringing new products to market, and one of the questions is like, what do you think the market looks like for something like this, right? Or is it niche? Is it huge? I mean, are we talking like, do you expect to make hundreds of thousands of dollars, millions of dollars? But a lot of times when you're inventing something, you are inventing the market for it too, right? You are the market, right?
Yes.
So it's really hard to tell.
It is. Yes. There are companies that will do patent valuations, and they will take your money, and they will do analysis, right? And their marketing, their business backgrounds, and at the end of the day, it's going to come with big disclaimers, especially if it's pre-revenue. Like, hey, we're assuming here, we're based on this general, bigger, more murky, competitive landscape and market value. And if, like you said, you're creating a hole, if you're operating in this gap where there really aren't any true competitors, that's going to make that more tenuous of a value.
And it's going to make finding that buyer for that asset, that unproven asset, harder to find too.
Yep, 100%.
Not that you can't do it. A lot of sophisticated people file patents in sophisticated technologies and never bring it to market and go sell it to a manufacturer who plays that field, right? That happens all the time. But yeah. All
right. Well, let's roll up our sleeves here. We got a little over 15 minutes, so maybe a little bit. We can go over a bit, but I want to talk about pricing, how much stuff costs. And I think breaking it down piece by piece is going to be the way to go. So I'm going to share my screen, Matt.
Great.
I'm going to go kind of more lecture professor mode for at least 5 to 7 minutes. Go through our pricing structure. Let me see if I can share the window. Here we go. Okay. And this is a nice simplified way to look at it. You got 3 big chunks of cost. And I like to think of cost or investment, of course, right? In both your time and in how much money you're paying us attorneys, and then also how much you're paying the USPTO, which is the government. So those are 3 different buckets of cost: time, attorney's fees, and government fees. So I'll try to cover as much as I can. First big section is this blue arrow, patentability. Is my invention worth filing? Is it worth moving forward to the next big arrow? And to know whether it's patentable, we start out with a free discovery call, Matt. We're willing to give a gift, the gift of helping you get to know us. We get to know you. It's free. You get to learn about our firm. And I think this is a nice way to start things out with low friction. But it does come with some time. You've got to be able to book that appointment, be serious, make sure you show up. And so we can get the information to you to help us, make sure you're someone we want to work with. After that, it's a legal consult. Sitting down with a registered USPTO patent attorney, I think is number one, is very, very vital for you to appreciate eligibility. Have you got an adjusted idea that you thought up in the shower, you use napkin sketched, or do you actually have a fully vetted, written, determined, fully fleshed out invention? And we'll kind of help you parse through where you're at on the spectrum, and if now your invention is ready for file. And so that's the legal consult. The output of that meeting is, should you move forward? Do you have enough of an invention? Are there any issues related to disclosure, statutory bars, multiple inventor situations, clarifying what your overall goals are? Patentability search opinion. This is our trademark offering here at Bold. It's $2,500. So it's a big, large investment to look before you leap. That's really what we got here. We've done this for years and years and years. Yes, you can pay all sorts of different fees online, on the internet, that are going to be less. Maybe you'll find some that are more, but we're toward the top of the market. We don't mess around with our inventors, our clients' money when it comes to giving an opinion on should you file or not. That is what the big cost is there. If you do decide to move forward with a look before you leap patent search opinion, we'll credit you for $1,000 toward a filing if the result of that search is to move forward. That's the first big piece, the first big blue, working with our law firm, our attorneys one-on-one to see just exactly what we think we can get you a patent on. Or unfortunately, if we end up telling you kind of the bad news, good news, that we don't think you should file, move on to the next invention. Moving ahead, if you do decide, if it's a green light, we got the green arrow here in the middle, patent application, 3 different major types of applications: a provisional or a non-provisional. If it's a utility, if what you've invented and what we think we can get you a patent on is functional, you're going to be one of these first two, the first bullet or this third bullet. And I've got these asterisks here, but so the first asterisk is it's $4,000 to do the filing if you did a PSO. Okay, $5,000, where you don't save that $1,000, but it's a $1,000 discount. If you didn't do the search, we're going to charge you an extra $1,000 because it's an effort, and because you came out, maybe did your own search. We need to go look at those results, do some extra work and heavy lifting. We want to be able to incentivize those that did do the work with us to move forward to the next stage. Now, the non-provisional, this price of $5,000 assumes that you did a provisional. Okay, some inventors like to do 2 steps, and oftentimes that's because you need more time to afford it, or more time to develop your invention. And you've got 1 year in general to file from when you file the provisional from when the non-provisional must be filed. So if you did the provisional, it's going to be another $5,000. So total of $10,000 if you go through this process. If what you've invented is not functional and it's just about the way it looks, it's a design patent application for $4,500. Also with a savings if you did a patent search with us. So it's a lot to unpack. If you have more questions, we can go back over that. The last step is after you file. Once you filed a non-provisional, then it goes to the USPTO. We'll cover the fees very briefly too. I think it's important to look at. This is called prosecution. And almost always, 95% of the time, the patent examiner, once it's been submitted, they will find something to pick at. They'll find some rejection. That's their job. They're just like the gatekeepers. And so they're going to find at least some prior art, some previously published application, issued granted patent, or a piece of published knowledge, whether it's a white paper, a journal article, something to say, what you're claiming is too broad. And so you need to come back and respond with legal arguments and amendments. And those are typically $2,000 to $3,000 each. And I like to tell people, figure 2 or 3 of those during this, what could be 1 to 2 years of prosecution here in bank. Trying to wrap things up, total cost for a simple invention, $10,000 to $15,000. For a more complicated one, $15,000 to $20,000 to $25,000 for a single patent. So I'm trying to pack a lot of things in here and simplify. This is how we do it here at Bold. The USPTO fee schedule is lengthy, and you can kind of go blind starting to look at it. But this is pulled right from the website, and it's pretty straightforward. There are 3 main types of fees. What's cool is that USPTO, they've found ways to try to save you money if you're a small entity or a micro entity. There's different ways.
I wish they did that on the trademark side, JD. That would be great.
It would be nice. I think
the trademark fees have gotten I think it's still good value for money, but they've gotten really expensive.
Okay. Yeah. Well, and so look at this. You're paying $70, and that's a fifth of what you're paying as a regular size entity. For a utility application, the basic fee, like I said, can be $70 or $140, depending on your qualifications, and they're going to be submitted electronically. 116T. If you want to file paper copies, I can't remember the last time we have, but it's an extra, $200 if you want to send.
I filed in paper in my career when the website goes down. You fax them in.
Oh my God.
You email fax them. Yeah.
Okay. All right. So there's lots of different fees here, but those are the big ones. Provisional has got specific fees that they just recently went up. And then for a design patent, it's a little different, by 10 or so dollars. So lots of different fees to think about when you get to the patent office. When the examiner assigns it, when it gets assigned to the examiner, you'll have to pay a search fee. Examiner does their own search, and then you're going to have an exam fee. Those are 2 different things. First they search it, then they examine it. And
I love that. I love that they it's a pay as you go. So you pay as the application continues through the system. I like that.
Yep. Lots of different things here. You can go for additional examinations. Usually you're always guaranteed 1 non-final and 1 final office action. And if you need to go keep arguing, you can do a continuation request for continued examination. And those fees are there. And when you get to the final, once they approve it, or what they call it, allow the application, you do have to pay again to issue it. So,
wow, this gets expensive.
It adds up even on the government side. So design all around $260. I don't know why they're off by $2, but they treat them a little differently. You can see different fees for international stuff. I won't get into too much of that.
Wow.
Okay. File very many plant patents. You can do a request for a republication, and then the fees go on here about extension of time. If for some reason you need more time, there's some issues regarding, dependency, or someone's, an inventor's sick, or there's, illness, someone's need more time, you can pay to extend it up to 6 months. So you can, they really charge you a lot on that 5th month. You better really want to keep that thing alive. If you do let a patent go abandoned, there are fees to request to have it revived down here. Anyway, have a look at the USPTO. There's lots of different things to pay for.
That's incredible, JD. I had no idea it was that expensive on the patent side.
Yeah. Well, let's pass the baton over to you. I'll stop sharing. If you have anything, I didn't prep you, but can you talk high level about government fees for trademark side?
Yeah. It's well, I don't even necessarily need to share my screen with you. I can kind of just tell you generally how they work.
Yep.
They're simplified compared to the patent side of things. So there's not as many, I guess, like gates or opportunities for the USPTO to charge clients. There's the initial application fee that clients are going to pay up front. Mm-hmm. And then there are some, I guess you would call them process-related fees as well. But for most clients, what they need to know from the USPTO government fee side of things is that the applications are now $350 per class at the USPTO. That's
Yep.
up from $250 about 2 years ago.
That's a big jump. Yeah.
Yeah, so $350 per trademark class. Most clients are in multiple classes, so expect to pay that fee multiple times.
Yeah.
From an extension perspective and proof of use or statement of use fee perspective, the government charges flat fees. $125 will buy you 6 months to, continue to extend your application. If you haven't gone to market yet with your intent to use application, you can do that up to 36 months. So you can file that 5 times essentially.
Yeah.
So it's $125 per 6 months per class. When you do go to market, they're going to charge you $150 for the statement of use. So that's your proof of use fee to the USPTO.
Reasonable.
Yeah, it is. I guess when I look at it from the patent perspective.
Yeah, I kind of like that seems reasonable-ish, for even an individual brand new startup. Maybe they should be charging more for larger entities.
Maybe, or what they could do is they could do it kind of like it seems like the patent side does, where they charge the application fee and then there's a registration fee at the end, right?
Yeah, right.
We basically say yes. Now you pay us the big money to register the trademark so you can enforce it. That might be something that they would consider doing too. I shouldn't say that out loud. I'll manifest it somehow.
Yeah. But there's no maintenance fees. I didn't talk maintenance fees. So patent side, you've got to pay every 3.5 years an increasing amount to maintain the enforceability of your patent.
Yeah. So we have some rules around maintenance of the trademark registrations on our side too, but they're between years 5 and 6 post-registration, years 9 and 10, and then every decade thereafter. So twice in the first decade, 3 times total in the first 2 decades. And those fees are more expensive than the application fees, but still pretty reasonable in that like $400 to $600 range.
Yeah, it's still enough to kind of put you at pause. Like if you haven't sold anything, you have no plans to stay in business, you just let it lapse.
And that's why they have these renewal periods. It's to get the dead wood out of the USPTO, because they know that folks aren't going to want to spend $600-700 renewing a trademark that makes them exactly $0.
Yep.
So it's a good thing ultimately. Although when you have to pay the money, it's not so fun.
No. And certainly, if you're a client, you're going to get the benefit of having someone represent you to remind you to make those payments timely. So there's no whoops, while you're in business, nothing goes abandoned or dies, while you're in business.
Yeah.
And
then you want me to talk briefly about like the trademark fees, our fees?
Please. Attorney fees. Let's do it.
Yes. Attorney fees. So we're flat fee, just like the patent side of things. Similar to how it is on the patent side, our fees are simplified, because our menu of services is a little bit narrower than you folks on the patent side. So generally, the clients are going to fall into 2 categories: clients that need a full search and opinion, like the works, and then clients who need us to do some consulting with them, do some searching, maybe no formal opinion or search report, more of a knockout search and move forward. We do a lot of that kind of work for clients. If we did the works for a client, it's $3,750 all in for a trademark for the law side of it. Search report, legal opinion, application, preparation, submission, docketing, office action responses, kind of statements of use, filings, all kind of included, separate from the government fees. A lot of clients are going to opt to just have us file the trademark application after doing a fairly comprehensive knockout search. And that's $2,500. If they have multiple classes or multiple applications, we'll do some discounting for those second, third, fourth classes. Generally, it's about 50% the cost of the first.
Yeah. Okay. So really big high level numbers on the patent side was more 10 to 20 grand.
Yeah.
What do you think? What's the trademark? All the way through.
I think for most clients, you're going to be in between 3 and 5.
3 and 5 grand. There you go. That's nice round number. No funny business. Of course, it goes up from there, but it probably won't go too much below 2 or 3 grand.
Yeah, that's
Yeah.
pretty standard for most clients. We keep it around 3 to 5 for most folks.
That's great. Well, good. Well, that I hope that helps those out there wondering about it. We've got the truth has been told on the cost, at least the legal side, on the attorney's fees here at Bold. And you're going to look, I think it'd be worth your while. If you're an entrepreneur, you should interview a few different firms, shop around, get some different quotes, but don't make price the only reason you decide to move forward or not. It's got to be a good fit for you, your business, how you want to work and operate, what you expect. And I think with us here at Bold, we are a boutique. Boutique is a fancy term, but it really just means we're not big and faceless. We don't have layers of paralegals and staff. You're going to know who we are. We have first names and last names, and we're going to work right there side by side. And that does make a difference. That does provide that additional hand-holding, that personal touch, and really understanding what your vision, what your goals are as an entrepreneur, as an inventor, and trying to make a difference in the world. So have a look. If you have any questions about pricing, I do have a website landing page where you can download that PDF that I showed. It's on our website with Bold Pricing. It's been a pretty good one. I'll show this off really quickly, and then we'll wrap up. And Matt, thinking about it, I should have something on trademarks up there for everybody.
Yeah, we'll figure something out.
Yeah, I've got Bold Pricing here. So if you want to click on this link, you can access the sheet. I do ask that you let us know who you are, and then you'll get a copy of that PDF. We're going to be able to just follow up, make sure you got it. And if you have any questions on the pricing, and you bet, if you've got an invention and you're going to hire an attorney, we're going to do our best to make sure that you hire Bold. So, Matt, that's all I've got. Anything you want to mention?
No. Good seeing you today.
Yeah, it's good to see you too. We'll be back next week. I've got some guests lined up, so I'm excited to share that. Check out our channel. We'll be here next week, Wednesday at 12 o'clock noon Pacific. Hope everybody has a good day out there. Go big, go bold.
Go big, go bold at boldip.com.